Hey, everybody, this is John Skiba with the Arizona Consumer Law Group, and this is the first of what I'm going to try to do with a series of live streams through YouTube to answer questions that you may have about dealing with debt collection lawsuits, bankruptcy. Let me give you a little bit about my background. I am a bankruptcy attorney and a consumer law attorney in the state of Arizona, and my practice is focused about 50-50 on helping consumers who need to file for bankruptcy, particularly Chapter 7 and Chapter 13. I also do a lot of defense work for consumers who have been sued by debt collectors, particularly junk debt buyers like Midland Funding, Portfolio Recovery, Calvary SPV, Unifund, and there's a million other junk debt buyers out there that we help people with. We also deal with a lot of debt settlement, some student loan issues, even tax issues. So I thought right now, particularly as a lot of people are dealing with the coronavirus, COVID-19 issues, and the economy is, obviously a lot of people are hurting already. There's a lot of uncertainty there. There's a lot of debt issues that people are dealing with, that I thought I would try to do these maybe once a week. We'll see if people want to do it. I get a lot of questions on the YouTube channel here, and I thought this might be a way to address some of those questions in a little more of a Q&A type setting. It's important to know I wouldn't be much of an attorney if I didn't disclaim a lot of what I have to say here. I'm only licensed to practice law in the state of Arizona. Doing these videos doesn't create any type of attorney-client relationship, which makes all the sense in the world because we've likely never met. I can't give legal advice about specific situations because I don't know all the facts. I don't know your documents. But what I can do is I'd like to address some of the questions that you may have. If you happen to be watching this live, then I would ask you to go ahead and you can put questions in the chat area there. I'll try to address those if I can. And then I'm going to go over some of the questions as well I have here on my phone that I get all the time on the channel itself. Now, the first question that I'm going to address has to deal with these stimulus checks that have been deposited into many people's accounts just recently. A lot of people are asking twofold. One, can creditors go after these? And two, if you're in a bankruptcy, is the bankruptcy trustee going to seize these the stimulus money that you're receiving? Now, to the first question, whether the creditors can go after the monies that have been deposited into your checking account, almost universally across the country, the answer is yes to that. There are some states that are trying to work to adjust laws relating to wage garnishment, but there's nothing in the CARES Act that Congress passed that limits this debt collectors being able to go after these funds. So if the money's been deposited into your account, you need to be careful about leaving those monies in because you may end up with a bank levy or some type of garnishment where they're going to come in and try to seize these things. Unfortunately, a lot of debt collectors are not seeing that this national crisis that we're dealing with, it should be a time to stop all of this. A lot of them are kind of ramping things up themselves. The other one is related to bankruptcy. Now, if you're in a Chapter 7 bankruptcy or you're thinking you may need to file bankruptcy, a question people have is, am I going to lose that money if I file? To answer that question fully, I have to give you a little bit of background so if you file a Chapter 7 is really designed to get rid of credit card debts, medical bills, unsecured type debts. They generally go away completely with the exception of most student loans and most taxes don't go away. But the trade-off is you're going to get rid of all that debt. But at the same point, if you have any assets that are not protected either under federal or state law, then a bankruptcy trustee can seize the asset and give the money to your creditors. So there's a concern that, hey, I just got this money, whether it's $1,200, $2,400, or if you have a bunch of kids like I do, it can be a lot more. They're wanting to know, am I going to lose this if I file for bankruptcy? Now, if you're already in a Chapter 7, if you're currently in a Chapter 7 bankruptcy, you're not going to lose it because in a Chapter 7, they're only looking at income that you had before the case was filed or income that you became entitled to after your case was filed, but you were entitled to it before you filed. So the bigger question is for people who are looking to file right now, and they're worried about, are they going to lose it if they file bankruptcy and then a week later they get the stimulus check? The answer there is a little bit complicated. The U.S. Trustee's Office, who deals with collecting these assets, they issued a nationwide order to all the local trustees saying, look, the law doesn't protect those funds in a bankruptcy case. But in general, we don't think these trustees are going to go after them, which the trustees I know, there are a lot of them that will go after them. Some of them have said that they won't, but in general, the U.S. Trustee's Office is kind of telling the other trustees to stand down and to not go after those funds. So I think it would be kind of a public relations nightmare if these bankruptcy trustees are coming in and sweeping those funds out from under people, particularly people that are dealing with financial problems already. So I think you can feel pretty safe. It's just my opinion. There may be other opinions out there where people are worried about losing those funds if you file for bankruptcy. I don't think that is going to happen. Let me go over a few of the questions. So Daniel wrote on there, is there any way to get negative accounts off your credit report after you've settled them? It's a good question. So this is governed by what's called the Fair Credit Reporting Act, the FCRA. The Fair Credit Reporting Act tells creditors if they're going to report information to the credit reporting agencies like TransUnion, Equifax, Experian, that they've got to report accurately. And so what you'll often see is you have an account on there and it gets, it's in a derogatory state, it's past due, and you go in and you settle it. They will update it, so they'll show that there's zero that's owed on it. But at that point, they're going to put a notation there that it was settled for less than the amount owed. That's generally what's going to happen. It stays on there for about 7 years and a bit, and then it will fall off. Now, as part of the negotiation, you can request that that they remove that line. And I can tell you that some creditors will do it, particularly debt buyers. I see them be a little more willing to delete the line altogether. But also they have an argument that I have a little bit of sympathy for, and I don't have a lot of sympathy for many of their arguments. But a couple of what they often will say is, look, under the Fair Credit Reporting Act, we are required to report accurately. I agree with them. And so they're saying, hey, this was settled. We've got to show that it was settled for less than the amount owed. And so they're saying that because that's what happened, that's what we have to show on the credit report. I agree with that, but there's also no requirement that they report to the credit reporting agencies, period. They can delete the line if they want to. It's generally just internal policy that governs that. So I always say you can ask for it. You should push for it. If it's the difference between getting a good settlement and not getting a good settlement, I would not let a good settlement fall apart because of that. Because the fact that it's settled, it actually pulls it out of that derogatory or collections category, and you'll see your credit score will go up significantly just because it's out of that category. So I don't know if that answers the question fully, but that's generally what you're looking at, unless they're going to be willing to voluntarily do it. Like you were saying, you can dispute it, and sometimes that'll make it go away temporarily. But if it's a legitimate account and the information on there is accurate, you're going to have to negotiate that off of your credit report or just wait for it to go away. Let me get a couple more questions. This is from Eduardo. He says he owes $100,000 in credit card and $60,000 in car payments, $460,000 in mortgage. If you file for bankruptcy, can you keep the house and the car? Now, there's two different types of bankruptcy. This is a good question. There's two different types of bankruptcy. There's Chapter 7 and there's Chapter 13. Most people file Chapter 7, and my guess, this is what you're talking about here, is that you want to file for Chapter 7. Chapter 7 is going to get rid of all of that credit card debt. Unsecured debt like credit cards, medical bills, if there's just personal loans that don't have any collateral attached to them, those will go away completely. Now, car loans and mortgage loans, they're secured. They have collateral attached to them, and they're treated differently in a Chapter 7 bankruptcy. Generally, if you want to keep the car and you want to keep the house, you just have to continue to make the payments on it. As long as you're making the payments on it, then generally you're okay. The only exception to that is if you have a lot of equity in the home or in the cars. So, for instance, in Arizona, where I practice law, the homestead exemption protects up to $150,000 of equity. So if you have a house, like in your situation, saying there's $460,000 that's owed on the mortgage, if as long as you didn't have more than $150,000 of equity, which that would be, I'm trying to do math on the fly here, $150,000 more. You know what? I'll get the calculator to make sure I'm giving you good numbers. As long as it wasn't, as long as your house wasn't worth more than $610,000, you'd be okay in a Chapter 7 because there's $460,000 mortgage on it, And as long as you're less than 610, you're going to be fine because you're under that $150,000 homestead exemption. However, if you had more than that, let's say the house is worth $700,000, they could sell the home, pay off your first mortgage, give you $150,000 for your homestead exemption, and then take the balance and give that to your other creditors. And the same goes for cars. I should have used a car example because that's where we see it more often, where in Arizona, each person, a person and their spouse each get a $6,000 exemption in a vehicle. If there's a disability plate, like a handicap plate on it, it jumps up to $12,000 each. But if you have more than $6,000 of equity above and beyond what's owed on it, you could lose the car. If you're under those numbers, it doesn't matter. As long as you're keeping the payments current, you're going to be fine there. Just a quick note on Chapter 13, because you do have to qualify for a Chapter 7. Chapter 7, they're going to look at your household size and your income, and you've got to be below certain limits. And it's different from state to state, so I'm not going to go over the numbers. You can look up the U.S. Trustee's office. They have a little table there that shows you what the income limitations are. They also change quarterly. So, but if you don't qualify for a Chapter 7, the alternative is to file a Chapter 13. In a Chapter 13, you're not going to lose any assets. But the flip side is you're going to have to make payments to your creditors over a 3 to 5 year period. So you won't lose stuff, even if you have more equity than what the exemptions allow. You're going to be able to keep everything, but you're going to have to make a payment to your creditors over time. Let me jump into one more. Heather says, Capital One hired Gerstel Law Firm and has sued me for a delinquent account. I'm negotiating a settlement with them. I offered 50 to 60%, but they want 85. How low do you think I can get them to go? Debt settlement is more, I always say it's more art than science on this or law on this, because really what you're looking at, you've got to look at it from their perspective. And what they're looking at is one, they've got a couple interests here. They've got their client who they're trying to collect for. Capital One, they generally sue on their own debt. You're not dealing with a junk debt buyer. Two, the law firm's going to get paid. They're usually paid on a contingency, or they get a percentage of what they collect from you. But they've got to look at how likely it is that they're going to be able to collect from you. That's going to make a big determination on what they're willing to take. And so they're going to pull a report generally on you. They're going to look to be able to see, do you own real estate? They've likely already looked at your credit report to see, are you currently employed? They're looking to see, are there wages to garnish? Is there real estate? Does it look like you have, stable income coming in? Or does it look like there's not much in the form of assets? You don't have a lot of, big car loans. They're going to look at all those things, and that's going to play a role in determining how low they're going to be willing to go on that. Now, with the coronavirus right now, that's something absolutely I would bring up in talking about settlement, particularly if you have been laid off, furloughed, if your hours have been reduced. And, I did a poll here on the YouTube channel a little while ago, and over 50% of the people who responded to that are dealing with that. And I think that's impacted most people. Most people are just not at work right now. And those that are at work and working from home, their hours are, have been reduced. And there's just not a lot of money to make those types of settlements. Not only that, my personal opinion is the country is probably facing just a tsunami of bankruptcy filings that's going to come here in the next few months. I've read a lot of articles on that. A lot of people are predicting it's going to be bigger than 07, 08 when we had the recession. So when I'm negotiating right now, I approach it from that, making sure that people are Gerstel, the law firm there, that they're aware of your current financial situation without giving them, don't give bank accounts, don't give, specifics, don't tell them where you're working, but hey, my hours have been cut, and explain any hardship that you're going through. Essentially help them make the case to their client why they should take a lower amount than the 50 to 60 or the 85% that they're going through. I'm just reading your thing here, Heather. Yeah. So if assets aren't showing up there, $2,500 debt, that's one of those things. If it's under $2,500, I mean, truthfully, it should settle for like $1,000. It's Capital One. It's an original creditor as opposed to like a debt buyer. Debt buyers will take less because they don't have as much skin in the game. They paid pennies on the dollar. the fact that you're furloughed, my recommendation would be to make sure you bring that up. That hey, I'm not having significant income coming in. I can pay you $800. I can pay you $1,000 and see if you can get that thing to go away. A lot of it depends on too if there's been a lawsuit filed or if they already have a judgment. If they don't have either of those things, then you're more likely to get a better deal because they don't have to go through the whole court process to get that done. So the approach I would take, you got to remember, at the end of the day, they want money. You're there to give them money. There's got to be some middle ground that can be reached. And if it's not a deal you can do, just wait. If they don't have a judgment, I mean, the credit's going to be damaged, but it's not something where they can do anything to you until they get that judgment. Once they have the judgment, they can garnish wages, they can go after bank accounts. But right now, you have some leverage there that they want your money and you're offering it to them. But they've got to make some concessions there. The other thing, which actually brings up from another question that someone had put on the site earlier, is that they had entered into a settlement agreement over the phone with one of these creditors and they got sued by them. Something you've got to be careful of is if you do enter into any type of settlement agreement, don't give them any money until you get it in writing. I don't care if it's an email, if it's a letter, if it's a formal settlement agreement, get something in place before you actually pay them any money. Otherwise, you're going to run into those type of situations. So, So Heather, I saw your thing there. My recommendation, because there's no judgment, sounds like there is a lawsuit filed, but they haven't served you. I would go ahead and just continue to try to work on some type of settlement. One thing to be careful of, I tell everybody, if you're avoiding service, just as a general rule, I'm not a big fan of it in Arizona because there are ways that they can get around that. You need to watch the docket online. You can actually log into the courts here in Arizona, the justice courts or the superior court, and you can see when they're filing different documents, because a lot of times they'll go try to get permission to serve you through what they call an alternative method, which is usually the mail nowadays. And so the problem you run into is that they can serve you in a different way that you may not see, and then all of a sudden you end up with a default judgment against you. So I hope some of that helps. You've got to be persistent on it. Again, they want your money. They've got to make some type of concession to it. So yep, stock the dockets. That's what you got to do, and then just keep on working through it. So I think that's the end of the questions that we have for now. And I don't want these to go too long, but I'm going to try to do these once a week. If there's other questions you have, feel free to go ahead and put them in the notes or the comments down below. I do check those. I come back and try to provide some input, but I'll try to do these once a week or so and respond to questions that people may have. But I appreciate all you guys checking in today, and we'll talk to you soon.